Okay, we're ready to go. Let's get started then. For those of you who don't know me, my name's Kurt Vest. I'm the enforcement engineer for the division. This is the third year in a row I've given this presentation, and each year the numbers get fewer and fewer, so maybe the word's getting out that we're just a bunch of boring engineers. So anyway, I'm kind of batting the cleanup position here because I'm basically covering all the remaining topics that haven't been covered by everybody else. So, it'll be 4 or 5 different topics here that aren't even related to each other, but let's just jump right in. Okay, we'll begin by talking about enforcement. I've been with the division now for 25 years, and when I first started with the state, this is how we handled enforcement. We had no enforcement authority, and it became very difficult when somebody was violating the water right because we were limited on what we could do. Prior to 2005, if somebody was violating a water right, the only thing that we could do is, if the statute allowed, we could file a criminal complaint, or we could take that violator to court and have a judge decide the case. As you know, that's kind of a lengthy process, and it's not something that you could readily do. I am aware of 2 cases in the Milford Valley where we did take some individuals to court and got a judgment against them, but it just wasn't practical on a statewide level to do that and enforce those violations. In 2005, things changed. We have an enforcement statute now. A lot of people think this is who I am. I'm here to tell you this is not who I am. I do not carry a gun and a badge. I do not have the authority to arrest you. I'm not a water cop. My authority is administrative in nature. And in 2005, the statute was enacted, giving the state engineer enforcement powers. And again, those powers are administrative in nature. What I do have authority to do is levy a fine. And also in 2005, administrative rules R 655-14 were established, which outlines the administrative procedures for enforcement proceedings before the state engineer. Okay, what authority do I have? I can initiate an enforcement action if somebody is taking water without a water right, or if they're violating an existing water right. I can initiate an enforcement action if somebody fails to comply with a statute, order, or notice regarding head gates or measuring devices. I can initiate an enforcement action if somebody fails to comply with an order or notice regarding dam safety or stream alterations. What I do not have authority for, I cannot go back in time more than 12 months. So if the violation occurred more than a year in the past, I do not have authority to go back and initiate an action. I cannot resolve civil disputes among water users. I cannot resolve internal disputes between irrigation companies or water companies. And I cannot resolve right-of-way, easement, or trespass disputes. And you'd be amazed how often I am asked to do one of these things. And I just have to tell them I don't have authority to address that. Okay, in order to commence, excuse me, in order to commence an enforcement action, the state engineer must issue what's called an initial order. So an enforcement action does not start when somebody files a referral with me. It doesn't start when I launch an investigation. An enforcement action starts when I issue an initial order. That initial order describes the violation. It makes the violator aware of any penalties which he may be subject to, and it notifies that individual that each day's violation will be treated as a separate offense. Through that enforcement process, if we get to the point where we issue a final order, through that order we may assess a penalty which can be up to $5,000 a day for each knowing violation, or $1,000 a day for each unknowing violation. Keep in mind, each day is treated as a separate offense, so you can see those fines can get pretty steep if they continue to violate. Through that process, I can require them to replace up to 200% of the water that was taken illegally, and they can be liable for the expenses which we incur in investigating the violation and stopping it. Okay, before we impose a fine, there are certain things that we must consider. We need to look at the value of the water that was taken during the violation. We need to look at the gravity of the violation, including economic injury and how it impacted others. We look at how whether or not the person complied with the state engineer's orders through that process, and we look at the economic benefit that was gained through that violation. And it's quite a lengthy process to evaluate each of those things. And the administrative rules that have been set forth outline the procedure that I must go through to evaluate and determine each one of those cases. Okay. When the enforcement program was started back in 2005, Kerry Carpenter was the enforcement engineer at that time. At that time, with this newfound authority, we actually did go out and initiated several enforcement actions and fined several people. Well, the first thing that happens is when you get a fine by the state engineer, you feel that you've been unjustly treated, and you go and complain to your legislator. And as a result, there were some threats made that this power may be taken away if we don't soften our approach. So when I took over in 2015, my instructions were to try and resolve all first-time offenses informally without having to go to formal, or without initiating an enforcement action. Now keep in mind, I still have the authority that was initially granted back in 2005. If the violation is serious enough, I can still initiate an enforcement action on a first-time offense, but to date I have not had to. I've been able to resolve all those cases that have come before me. Any second-time offender, we will go through the enforcement process and probably levy a fine in that case. So that's the approach that that I am taking now as the enforcement engineer. I try to resolve things informally with the violator with the intention of getting the violation to stop and getting them in compliance without having to drag them through that difficult process. Keep in mind, though, I still carry a big stick. I have that power to levy a fine. Question?
In your slides, it said a person may be fined, but is this applicable to like an irrigation company or a public water system as well? Can they be fined for violating their?
Yes. It would have to be shown that what they're doing is either using the water illegally or in violation of their current rights. So they have to be doing something that's not consistent with their underlying water rights. I've never had a case with a company well, I shouldn't say municipality because I have one right now that deals with a municipality. But yeah, I do have that authority. So, but to date, I haven't had to deal with any of those entities. Any other questions on enforcement? Yeah.
The slide indicated that you had the slide indicated that you had a year from the time of the violation. In fact, is that from the time of the violation or from your notification?
No, that's from the time of the violation. So if that violation occurred more than 12 months ago, I can't do anything about it. If it's happened within the past 12 months, I can address it. The problem with that is if it's occurred in the past and I haven't witnessed it, then I have to rely on whoever submitted that to me as a witness. And through that enforcement process, we try and keep those referrals confidential. We don't give out who filed a referral with me. If I were to go after a violator that happened in the past that I didn't witness, all I could do is rely on, other people's testimony as to what happened. So it becomes difficult. It really becomes key that I witness what happens. So I can go back in time, but I have to either have witnessed it or have some sort of evidence showing that a violation did occur. Any other questions? Okay, we'll move on to dam safety. This image here is a picture of South Creek Dam, which is located on a tributary of the Virgin River. Back in 2010, we had in December of that year, we had a significant rain event in southern Utah, and I got a call saying that South Creek has something going on with it and that failure was imminent. Nathan Moses and myself hopped on a helicopter. They flew us into the dam. This is a picture we took from the helicopter when we arrived. And when we landed and walked the dam and inspected it, what we realized is the overburden on the dam got saturated, began to slough off, but the core of the dam was still intact and there was no threat of failure. We got back in the helicopter. We thought they were going to take us back to our vehicle. Instead, they flew us to St. George and wouldn't take us back to our vehicle unless I held a press conference. So they wanted somebody to blame if things went wrong. That was a bad day for me. In 21 years of inspecting dams, what I've found is that most of your larger dams are well maintained and in good repair, and most of your small dams are poorly maintained and are in disrepair. So let's talk about the authority that the state engineer has to regulate dams. The state engineer may make rules controlling the construction and operation of dams. These rules include the design, maintenance, repair, removal, and abandonment. The state engineer may exempt dams that are smaller than 20 acre-feet, and if they were to fail, would not threaten human life, and any larger dam that if it were to fail would not threaten human life and would only cause minimal damage to the owner's property. Okay, anybody who is working on designing dams must be an engineer licensed in the state of Utah and must have experience designing dams and construction. Written approval must be obtained by the state engineer prior to commencing work on any dam. Whether it's a large dam or a small, you need a permission from the state engineer. If the dam is more than 20 acre-feet, you need to submit formal plans. If it's less than 20 acre-feet, you still need to file what's called a small dam application, which allows the state engineer to review the water rights for that dam and determine a hazard rating. So no matter what the size, you need approval from the state engineer prior to commencing construction. Okay, let's talk about inspections. The state engineer has an inspection program where we regularly inspect dams throughout the state. The state engineer may issue orders as a result of these inspections, which may require engineering studies, it may require repairs, may set storage limits on that dam, may require them to remove the dam or to breach it, or any other remedy which the state engineer feels necessary. It is the owner's responsibility to maintain and keep that dam in good repair. I would just say that you need to take these inspections seriously. There was a dam in the Santa Clara area a few years back where in prior years we had in our inspection noticed that rodents were causing damage to the dam, and the owner ignored our report, and lo and behold, I got another call to go inspect the dam that was failing, and when we got there, you could see the water shooting out of the gopher holes in the side of the dam after it had failed. So that was a case that had they maintained and done what we'd asked them to do in our inspections, they probably could have prevented that from happening. Any questions on dam safety? Okay.
As I understand it, you get a call from St. George that a dam is in imminent danger of collapse. You fly down, you see the overburden sliding away, and then you walked across the dam.
Yeah.
Was there something that told you it was safe to walk across the dam at that time?
Yeah, we could see that it was
You could
structurally
see ahead of
intact.
time. It wasn't one of
Yeah.
those I'm sacrificing myself
No.
situations. Okay.
Yeah. It became pretty obvious right at the beginning what was going on there. The core of the dam was in place and that there wasn't any threat of failure. So, yeah. Any other questions? Yeah. Yes, yes.
Can you say that increase of
Yeah. The dam is the structure that backs up the reservoir. Yeah.
It could be called a reservoir.
Yes.
Okay.
Yeah. Okay, let's move on to stream alterations. Every time I see this photo, I have to laugh because just for your information, Detroit riprap is not an approved riprap material, but we see it all over the place. Somebody mashes up an old car and puts it in the bank of the stream to protect the stream. Anytime you divert water from a stream, you need a water right. And to initiate that diversion, obviously you have to do some work in the bed and embankment of the stream to install that diversion. Keep in mind, anytime you alter the bed or bank of a stream, you must first have a stream alteration permit. And these permits are approved under the Clean Water Act. So anytime you alter a stream, just know you have to get a stream alteration permit. For non-commercial applicants, that fee is $100. For a government applicant, that fee is $500. And for a commercial applicant, the fee is $2,000 for a stream alteration permit. Yes.
With the stream alteration, what would happen, say, there's been a diversion for, decades, and a lot of water comes down and washes that diversion out. Can you go back in and restore that diversion, or do you have to go through the process of being approved to put that diversion back in? Say it was washed out.
Yes, you can go back and restore it after you've filed your stream alteration permit.
How long does that usually take?
Boy, it's not that long, and it probably is a case-by-case basis, what issues they see there. Typically that we,
Well, maybe you'll get to it. I hate to interrupt, but it's a fairly short time frame to get a stream alteration permit, but there is also a provision for granting emergency stream alterations.
yes.
And maybe
Yeah,
I shouldn't have cut in first.
No, and thank you for pointing that out, because, yeah, if there is an emergency and you need to get it, yeah, you can do that work and then go through that process afterwards.
All right, thank you.
But yeah, you do anytime you alter the bed or banks of the stream, you should file that application. Yes.
You have a stream altercation and or alteration and a dam question. Say you have a stream running through your property and Mr. and Mrs. Beaver show up and build a dam. I didn't do it. I didn't want it, but they're natural creatures. What do we got to do with that?
Typically, you can remove that dam without altering the bed or banks of the stream. So
And the beavers will replace it unless you get rid of the beavers.
Well, that's another issue you have to deal with. But yeah, you can go in and remove vegetation and debris without having to get a stream alteration permit. Yeah.
What's the relationship between what we're talking about here and what the Army Corps of Engineers, or is it all the same?
It's that authority is granted us through the Corps of Engineers.
So do we initiate the process?
It's
through
a
you?
joint permit is what it
Okay.
is. Yeah.
Okay, thank you.
And through that process, they get notification, so they have an opportunity to jump in if they feel that there's something there that concerns them.
Maybe I ought to clarify
Oh.
a little there. We have separate authority under Utah state law from what the Corps has authority for under federal law. We have a permit, a general permit from the Corps to permit certain types of stream alterations and have compliance under their requirements. So what happens is if you file an application and file it as a joint permit application, they automatically get a copy of it. They will tell us whether it's covered under our permit or whether you need to get a special or separate permits from them.
Okay. Any other questions on stream alteration? Now, you look at those fees, we didn't come up with those fees. Those fees were established by the legislator. So, it's interesting, the I don't know how they came upon that, but, those are the fees that are set. Okay. Stream alteration, actually, there's two, I think, in the state. He asked what the name of the person over stream alteration in the state. Chuck Williamson is one of them, and Darren Rasmussen is the other. Is that all that, or they, yeah, those are the only two that cover that in the state. Okay. Okay, let's move on to groundwater recharge and recovery. This is an aerial photo of Sand Hollow Reservoir, which is located in Washington County. This reservoir was built over a sandstone formation, and they knew when they built it that it was going to seep into that formation. Ron Thompson, being the forward-thinking guy that he is, he filed what's called a recharge and recovery application. All those red little bullets you see there are locations they have approved for wells that they can now drill into the formation and recover the water that has seeped into that formation. You know, they measure the water coming into the reservoir, they measure the water they take out, they measure the evaporation from the reservoir, and with that information they can tell how much water is seeping into the sandstone formation. And they have approval to recover that water through those wells. That's just one of many cases throughout the state. So let's talk about groundwater recharge recovery. A person may not artificially recharge an aquifer without first obtaining a recharge permit. Also, a person may not recover water that has been recharged artificially without first obtaining a recovery permit. Anybody who is proposing to artificially recharge an aquifer must first have a valid water right to do so, or have an agreement with somebody who does have a valid water right. And if you file a recovery permit, you can only recover the amount of water that remains in that hydrologic area of influence. And there's things you have to do to show that. Let's first talk about the recharge permit. Now, you don't have to file a recovery permit just because you filed a recharge permit. They are two separate things, and we have several cases throughout the state where recharge permits have been filed without recovery permits. Down in southern Utah, we have several basins that are over appropriated, and several of the government entities in those areas have filed recharge permit and have approval to take excess surface water and recharge it into to the aquifer to try and offset that imbalance. So it's not a case of they're storing water for future use, they're putting water in there to try and alleviate the problems with groundwater declines. Okay, so on a recharge permit, you need to identify the groundwater basin. You need to have a legal description of the proposed recharge point. You need to know the source and the amount of water that you're going to recharge and have a valid water right for that. You need to identify the quality of the water that will be recharged as well as the quality of the water of the receiving aquifer. And you must have necessarily have obtained permits from water quality as well as from water rights in order to get that permission. You must submit a plan of operation. This plan shall specify the design capacity. It will detail a monitoring program and outline how long the project will last. Part of this recharge application, you must conduct a study. You need to determine the hydrologic impact the project will have. You must determine if it is, first of all, hydrologically feasible, and that the project will not cause harm to property or impair any existing water rights. This study must also determine the percentage of water that you're anticipating can be recovered through the project. And you need to show that you have the financial and technical capability to complete the project. There is a filing fee with a recharge permit, and it is based on the amount of water that you will be recharging. It just follows our standard fee schedule for normal change applications or appropriations. Okay, the recovery permit. Okay, with the recovery permit, you must identify the legal description of the wells where you will recover the water, identify the source that you will be tapping into to make sure it is actually water that you've recharged, determine the depth and diameter of the wells, and you must identify the land where the water will be used on. There is a filing fee with a recovery permit, and that fee is $2,500, a flat fee of $2,500. Along with a recharge and recovery project, the state engineer will set up a storage account, which you then, as the owner of that permit, must monitor the operation of the project and its impacts. You must file reports with the state engineer that will state the quantity of water that has been stored as well as the quantity of water that has been recovered. And you must show the quality of the water, both of the recharge, the quality of the water of the aquifer, and the quality of the water that is being recovered. There is an annual fee that's assessed that covers the state engineer's cost of operating this storage account. Okay, any questions on groundwater recharge and recovery? Yes. It's a race.
How do you distinguish between stormwater, like injection sites, like dry wells? Does it actually have to get down to where it enters the aquifer, or is there a line distinguishing between the two?
Well, I think first of all, the thing that you are responsible for is the water that you are putting into the system.
Right.
With your water right. Now, the only concern about
Well, it's not
the only
related-
concern about stormwater would be quality.
Okay.
Most of the systems that I've dealt with, they're recharging into old gravel pits where there's a natural filtration system that takes place, and that stormwater was getting in there anyway.
We're just speeding up the process.
yeah.
Okay.
Obviously, if your point of recharge is a point source, you probably need to make sure that the only water that's being recharged is what you intended to recharge there. That's I've never heard that question before.
Kurt, to
Yeah.
add to that, I mean, I presume these are shallow wells, but there's another component to the recharge application, and that's that you have to have a permit from the Division of Environmental Quality.
Yeah, yeah,
And they will, mostly on well recharges, the water quality has to be municipal grade treated water, so.
yeah. And I quickly mentioned that when we talked about it, but yeah, they would be the controlling factor there of issuing that approval for water quality. But in the cases that I'm aware of where they are recharging through gravel pits, there was storm water already getting into those, so that was kind of a non-issue there. But any other questions? Okay, our final subject, reuse of wastewater. I don't think this is quite what we mean when we say reuse of wastewater, but the technology's there that they can treat it to that standard. But I'm not aware of anywhere where we are doing that. But okay, reuse. What we're talking about here are public agencies who own or operate a publicly owned treatment works, a sewage treatment facility. And if you are a public entity that owns and operates one of those treatment works, there is a potential there to apply for reuse of water. The water right that we're dealing with here has to be a municipal water right, and the reuse of water must be consistent with the underlying water right. You can't have any enlargements of the water right by approval of that reuse. The public agency must receive approval from both the Water Quality Board and the state engineer. Okay. If the public entity does not own the water right, they can still do a reuse application if they have a contract with whoever owns the water right, and that water right is administered as a municipal water right, and then all other conditions apply. Okay. With the application process, that application shall include a description of the underlying water right and an evaluation of the water right's diversion, depletion, and return flow requirements. It must estimate the quantity of water that will be reused, and an evaluation of the depletion of the hydrologic system must be conducted. Basically, you can get an approval to reuse if you can show that you won't enlarge the underlying water right and that all the historic return flow requirements are met. So where this, now you say, if these are municipal rights, can't they just consume all the water? Yes, if the water right was initially set up as municipal, but if the municipality went out and purchased, say, an irrigation right, transferred that into their system as municipal, they have historic depletion limitations to that water right. So through this process, they have to show that they won't deplete any more water than what was historically depleted. And you say, well, how does that work? Say you purchase a water right, irrigation right, that's, say, 60% depletive historically for irrigation. You transfer that to municipal. You still have those depletion limits. But through most municipal systems, most indoor uses are about 20% consumptive, and about 80% makes it to your treatment works. So based on that, there's still a percentage of water that can be depleted there without exceeding the historic depletions. So that's the type of analysis they have to show, that there's still water that can be depleted and they're not going to exceed that depletion of the historic water right. Any questions on wastewater reuse? Now, keep in mind, this is just public entities that can do this.
Right. So on the, if you're a district and you have multiple cities that are putting into those, you put all those cumulatively and you can redistribute once you do the analysis. Is
Yes.
that correct?
Yes.
Thanks.
Yes. All the water rights that go into that treatment facility have to be accounted for. And you have to show that by reusing a portion of that, that you're not going to exceed the historic depletion. So, any other questions? Well, that concludes my portion of that. You know, why is this important? You know, you've just spent 2 days being bombarded with rules and regulations regarding water. What we need to consider here is water is the limiting resource here in the state. There's only so much to go around, and we need to use that water beneficially. And that's why this is important, and that's why we have all these rules and regulations. Any final questions? Okay, thank you.